Welcome to Rightly Decided, the mostly originalist takes of the litigators of the Texas Public Policy Foundation. I'm Laura Beth Latimer, and I'm here with our Director of Litigation, Chance Weldon, and Attorney Nathan Seltzer. And ordinarily, we would be bringing you Supreme Court cases as they drop. But at a certain point, I feel like we should just give up that ghost, because today we are yet again not talking about a Supreme Court case. I tried to convince them to talk about whether or not driving away with the car door still open is reasonable suspicion of a crime, but they weren't interested. So instead, we are talking about a drop from the Fifth Circuit that came out this last week about Texas's Ten Commandments case. So
Can I correct the record on that real quick?
Yeah.
I am interested in the Supreme Court case. This is just way more interesting. Yeah. So.
I have to agree with that, which is why I didn't push back on this idea. So the case we are talking about is Nathan versus Alamo Heights ISD, which deals with the case that dropped, with the statute that was dropped in 2025 requiring that the Ten Commandments be posted in all classrooms in the state of Texas. So there's some nuances to this that I'm going to go into a little bit, and then we'll talk about what the court did. So the statute itself required that the Ten Commandments be posted, and it gave specific instructions as to where they needed to be posted and how big the signs needed to be, and provided that
the version of the
language of the Ten Commandments necessary, and provided that if the Ten Commandments were donated, that the school could use the donated versions, or if there were no donated Ten Commandments, that state funds could be used to purchase Ten Commandments to put in these classrooms, again, following these very specific criteria about how they looked. The Fifth Circuit on this took it directly en banc, and so there's a lot of justices talking in this opinion. And they held that it was fine, that the Ten Commandments could be posted and this law could go into effect. So we're here today to talk about why that's kind of a weird result, and where we kind of start with all this. So all of this should sound a little bit familiar, because once upon a time, this case came before the Supreme Court in a case called Stone v. Graham. This almost exact same situation was at issue in Stone v. Graham. And the court held under a case called Lemon, we'll talk a whole lot more about Lemon in a few minutes, that this was a violation of the Establishment Clause. So the big question that's in front of us today is, why doesn't Stone control? And is this a violation of the Establishment Clause or not?
Go ahead.
I would say first we should probably say what the Establishment Clause is for those.
That's true. I always get ahead of myself. Chance, what's the Establishment Clause?
It's in the First Amendment, and it says that the government cannot establish a religion.
Is there more to it in the text of the First Amendment?
Yes, but I don't remember it off the top of my head. Okay. Like, I'm not going full Rain Man on the...
Okay. So, but the Establishment Clause is bound in the First Amendment. It's one of the clauses of the First Amendment that prohibits the government from establishing a religion. And for many, many years, our kind of guiding light, albeit flickering, was a case called Lemon v. Kurtzman. But Lemon v. Kurtzman, as of 2022, I believe, was overturned, although it's been chipped away at a whole ton over the years in a case called Kennedy. Nathan, I think you had the language from Kennedy talking about what actually happened, how the court...
You want to start with Kennedy?
Just a little bit. Just give us a little bit on Kennedy.
So Kennedy declared the Lemon test basically dead. They said, here's the quote, "But given the apparent shortcomings associated with Lemon's ambitious, abstract, and ahistorical approach to the Establishment Clause, this court long ago abandoned Lemon and its endorsement test offshoot." And then it cites a case from that same year, which was a plurality opinion. So we're chuckling because it's like, we long ago abandoned it, but I can't give you a case citation that's old.
So at least as of last year, we had abandoned it, probably in a plurality.
It's a bit of a retcon, maybe.
Maybe a little bit.
But when we get into Lemon more, we'll see that it's just unclear what the Lemon test even was. So
right. And we'll get into Lemon more a little bit later on. But for right now, let's just assume that Lemon is overturned. And we have this case, Stone v. Graham, that's decided under Lemon that is almost identical facts to the facts in this case. How do we get from this Supreme Court case, because Stone v. Graham is a Supreme Court case, to Fifth Circuit can say that Supreme Court case doesn't bind us anymore, and we're going to go off and create our own test and our own liturgy for this particular issue?
So I think it's important for the listeners to kind of unpack how it would normally work. So you have what's called vertical stare decisis, to use the formal term. And that basically says that the lower courts have to follow the opinions of the Supreme Court in cases that are analogous. So in analogous cases, if you're a lower court, the Fifth Circuit, for example, even if you think the Supreme Court's decision was wrong, even if you don't think it's an originalist precedent, to a certain extent, you have to follow it under this concept of vertical stare decisis. But the question becomes, when is a case still a precedent that you have to follow under vertical stare decisis? And what the Fifth Circuit says here is, look, Stone, the case Stone, was based explicitly on Lemon, right? This case that we were talking about, and we'll talk about more later. And Lemon now has been overturned. And so does Stone fall with it? Or does the court have to continue to apply Stone even though the underpinnings of Stone have been washed away? And what the Fifth Circuit en banc says here is no. When Lemon fell, all of its progeny kind of fell with it. And there's an argument for that if everyone remembers, say, Plessy versus Ferguson, which upheld segregation. When that case was overturned later in Brown v. Board, all of that segregation as precedent sort of fell with it. They're making a very similar argument here that even though Stone would appear to be directly on point, because Lemon's overturned and Stone relies on Lemon, then Stone falls with it.
Mm-hmm. I agree with you that's obviously what the majority says, and there's a good argument there. Just to play the devil's advocate for a minute, though, Lemon didn't come out of nowhere. This is something that's brought up by both of the major dissents in this case. Lemon didn't come out of nowhere. It was based on other opinions that themselves are still good law. And in fact, the case that overturned Lemon, this Kennedy case, cited back to some of those older precedents that Lemon was based on. And so therefore you can't say that there's no longer any legs to this, because some of those older precedents that still exist and are still good law are still upholding Stone. So if you just kind of cut off Stone and say, yep, there's no basis for that in law anymore because Lemon is gone, you're ignoring these earlier cases on which Stone could still rely. And now I'm not necessarily saying that that's false, but I think what I'm saying is that it's not up to the Fifth Circuit to make that determination. It's up to the Supreme Court to make that determination, right?
Well, I think if we use an analogy for this too, like Stone is a house and it's built on the foundation, and part of the foundation of the house is Lemon. And so the question is, like, what portion of the foundation of that house is Lemon and what portion is like Walls v. Tax Commission of City of New York and some of these other cases, and if enough foundation's been removed that we can no longer rely on Lemon, I think.
And I'm saying the question is who gets to decide, right? Who gets to decide that we can no longer rely on Stone? Is that something that the Fifth Amendment has the liberty, they take the liberty to do, or is that something that they should say, look, we've got a case directly on point, that's the controlling precedent. When this gets to the Supreme Court, they can overturn it, and here's the reasons why we think they should, but, decision of the district court is affirmed dubitante, doubtfully.
I mean, that really is the fight that happens at the Fifth Circuit here, because there are really two forms of this, right? There's a really strong version that says, look, if there's a case directly on point, we don't get to guess the extent to which it's been undermined, and we just continue to apply it, even if all of the foundations of that case and everything that case relied on have been gutted. We are just robots on the Fifth Circuit, and we're going to apply it until the Supreme Court tells us otherwise. And that's one form. The other form is the Fifth Circuit has some freedom to say that the precedent itself has been undermined. And that's why I gave the example of, say, Plessy, because everyone knows that's the separate but equal case where you had racial discrimination. And there were a lot of other precedents that built upon Plessy. And then Plessy was overturned. And then the question would be, going back to the Fifth Circuit Court of Appeals, does that appeals court still have to follow all of those other racist precedents, all of those other segregationist precedents, until the Supreme Court overturns each one of them explicitly? Or once Plessy was overturned, did all of its progeny kind of fall with it? And so you have one side of the Fifth Circuit saying, we can do that. We can say that, like, once Lemon was overturned, Lemon's progeny falls with it. And then you have the dissents in this case, which are arguing, no. Until Stone itself is explicitly overturned, you have to follow Stone, even if it's explicitly based on Lemon. And I think that's the debate that's going on in the Fifth Circuit.
And just to remind everyone where we are, so Stone was dealing with the Ten Commandments. So, like, this is just yet another Ten Commandments.
Very specifically, almost identical to this case at hand.
Yes.
Right. Yeah. And so Stone, if they just applied Stone mechanically, the law would have been struck down. But because they don't feel like they need to apply Stone mechanically, they upheld Texas's law. So that's where we stand now. And that's why we're arguing about whether or not Stone controls and how Lemon affects it and all that kind of stuff.
And so what's interesting is once, say, for example, Lemon is, if Lemon's overturned and that precedent's washed away, then the question becomes, how does the Fifth Circuit decide the case? Like if Stone is gone, that frees them up to start doing like originalism, to start looking at what the original public meaning is, to look at prior precedents of the court which weren't tainted by Lemon. And that's what the court did in this case. They said, look, Lemon's gone. Now we have to figure out what the test is based on what the Supreme Court's given us, right?
Yeah, absolutely. And I think as we are making this determination, it becomes very apparent very quickly what the judges believe the role of these of the middle level managers. I've heard the Fifth Circuit judges refer to themselves as middle level managers. Mm-hmm. What is the role of the middle level manager as we are unwinding what Lemon has done? Yeah. I don't know that there's a good answer, honestly, because we may or may not agree with the outcome in this case. We may or may not agree with it in a different case, but it's ultimately just sort of a pragmatic question. What can these judges do and what should they not be doing?
Well, I think it's also a legal question. I mean, vertical stare decisis, that lower courts are bound by the decisions of the Supreme Court, is an important principle, right? Because you want law to be settled at some level, and you have appellate review for a reason. But you need to be able to articulate a reason, like you need to be able to articulate a theory that lets you make the decisions that you're making. So you have to have a theory of stare decisis. And I think what the majority's theory of stare decisis here is basically once you've swept away a precedent, that its progeny goes with it, or at least when you've clearly swept away a precedent, that its progeny falls with it. And certainly as someone who practices in a space where we're trying to overturn sometimes precedents, that's going to be fun for us.
Yeah.
But it's important to kind of think that through depending on what side of the V you're on.
And I don't know if we said this, but it was a razor-thin margin, right? Like 9 justices are saying that we don't need to follow Stone, and 8 are saying that we do need to follow Stone. So it's turned on one vote.
Yep.
Yeah. I think it's interesting, too, to note that there was a Louisiana case that was very similar to Texas's ordinance that came up and was cast aside on ripeness. But Judge Ho, who ended up authoring a concurrence in this, authored a concurrence in that same ripeness case in the Louisiana Ten Commandments case. And Judge Ho's decision or his opinion in that case ultimately becomes the majority position in this one, which is just a fascinating kind of turn of events. Okay, so let's turn to the tests themselves. I promised that we would talk about that. But before we get to the tests themselves, I just have to take a point of personal privilege to talk about a footnote in this opinion, because footnote 1 in the majority. Yeah. So the district judge wrote an opinion that the majority describes as creative. And then the court footnotes some of the things that this court did, and they quote several times from this majority opinion. And in the quote, they bracket and add Oxford commas to the district judge's opinion. And that's a side eye.
That's correct.
Which is correct.
Which is correct. We are an Oxford comma bunch here. But it is a judicial side eye, if I ever saw one, to bracket an Oxford comma.
As someone who loves the Oxford comma and thinks that it is the appropriate way to do list, particularly in legal documents, I just felt very seen.
It was nice, but it was also just sort of like a come on, you could do that. Yeah. So clearly they were not pleased with the way that the district judge had drafted his opinion.
But it wasn't just that. I mean, the lower court's opinion, which they quote in that footnote also, they do add some Oxford commas, which is correct, but they also are explaining themselves, like, why are we calling out this judge a little bit? And one of the things is that the lower court's opinion, so not the opinion that we're talking about here, but the lower court's opinion in this case, concludes with a prayer. And it says, for those who disagree with this court's decision and who would do so with threats, vulgarities, Oxford comma added, and violence, grace and peace unto you. May humankind of all faiths, beliefs, Oxford comma, and non-beliefs be reconciled to one another. Amen. And so the lower court was being a little bit sarcastic with its opinion, and I think the appellate court here is calling them out a little bit for that sarcasm, that we don't necessarily need that. And there were some other things they put in this footnote
Yeah, it's
also.
super tongue-in-cheek. They
Yeah.
were the district court was being very, and I think they probably believed, I don't know which district judge this is, but probably saw this as an easy affirmation from the Fifth Circuit because Stone is directly on point.
Yeah.
So they probably thought the Fifth Circuit's going to be on my side on this one. And I think we were all a little surprised, at least at this table, we're a little surprised that they were wrong, in spite of Judge Ho's concurrence earlier this year. So let's talk about the opinion itself. First, Nathan, I'm going to ask you to lay out the Lemon test, because in order to understand what's changed and how this Establishment Clause test rolls out, we have to establish what the Lemon test was for determining when the government has committed an Establishment Clause violation.
Yeah. So Lemon v. Kurtzman, let me take you back to the sweet spring of 1971. So
It was beautiful, beautiful summer that spring that year.
Yes, I remember it well.
He's kidding. He's not that old.
Correct. It's 55 years ago, though, is how far we have to go back to get to the origin of this decision that we're talking about today. So Lemon v. Kurtzman, Supreme Court decision, outlined a three-part test over what constitutes an establishment of religion. And it says, first of all, the law needs to have a secular purpose. Second, the primary effect does not advance or inhibit religion. And then the third prong is that there's no excessive entanglement with religion. And the first cases applying this precedent are really focused on that excessive entanglement and like what that means. And the court gets a few years down the road, about a decade or a little bit more down the road, and then Justice Sandra Day O'Connor, in a concurrence, adds sort of a twist, a lemon twist, if you will.
Oh my gosh.
Sorry, I'm a dad. I had to. And Lynch v. Donnelly, and says that we're going to use the lemon test, but we're really looking at is whether or not we're going to look at it through a lens of whether or not the law endorses or disapproves of some religious tenet. And so that's used a little bit by the court for a little while. And then we get to Levy-Wiseman in 1992, and we're going to twist it again a little bit. And now we're going to look at whether or not there's a coercive effect when applying this. And again, we're kind of looking at the excessive entanglement prong and whether or not there's a coercive effect. But as Justice Scalia noted in 1993, which is just a little bit after Levy-Wiseman, sometimes the court doesn't apply Lemon. So the court is looking at establishment, and then they just said, oops, we just forgot.
Well, it's also before we even get to Lemon being a zombie for a long time, which it was.
Right.
But, when they were building out this test, I mean, were they looking at the original public meaning of the Constitution? Were they trying to understand original sources?
Which Supreme Court was in power in the 1970s?
In 1971? I mean, it's the Burger Court?
I think that's the Burger Court, yeah.
Is the Burger Court doing a deep dive on the original public meaning to build out Lemon, or is this just vibes?
Yeah, and that's when we get to Kennedy, eventually declaring it dead.
Kennedy, not the justice, Kennedy the case.
Yes, Kennedy v. Bremerton School District in 2022, when it declared the case to be dead, that's what it says, is that it was an ahistorical approach to the Establishment Clause. And we don't want to be doing that sort of jurisprudence anymore, and so what are we going to replace it with?
I think it bears going into some of the confusion on this just a little bit more, because this isn't just like, oh, sometimes the court does Lemon and sometimes they don't. It was so, even, let's see, I went to law school 6 years ago. Nathan, you went to law school since then. But I know I learned in law school that Lemon was good law with lots of exceptions. And now we fast forward, let's see, 2025. The court is behaving as if it's been overturned for generations, and it just hasn't. And even in our law schools, that confusion still exists and pervades as to what is Lemon and what is not Lemon.
I mean, it had been a test in hard air quotes for a while, because it was almost like case-by-case adjudication, case-by-case, like this fact works this way, like a lot of the sort of Sandra Day O'Connor multi-factor balancing tests that came out of, the 80s and 90s. It was really unclear for the folks on the ground to figure out what it meant. It was hard for courts to apply it, and sometimes courts didn't apply it.
Yeah.
And over time, like a lot of these Burger era precedents, it was still out there making a mess of the lower courts, but the Supreme Court had been moving away from it and not applying it or ignoring it for a long time. But as Scalia had said, it roamed about like a zombie through the countryside.
And when we say zombie, we're largely talking about the effects of it, right? Because it had so much progeny. It just like there were so many cases that were sort of based on Lemon tangentially, and then there are cases that are based on those cases, and the Supreme Court would quote to those cases but not to Lemon, and sometimes they would just take one prong from Lemon and ignore the rest. And so we ended up with a situation where the Lemon test itself was fundamentally dead for a very long time.
Yeah.
But because of all of this other nonsense, it was hard to know what we should be applying and what we shouldn't.
And not in the district court or in the lower court level. I mean, if you're, say, for example, a school district attorney trying to figure out whether or not, Coach Kennedy can pray or whatever, that's what brought that case up, is they were afraid of the Lemon test. They were applying the Lemon test when deciding whether or not to let a teacher pray, for example. And so at the lower court level, much like when the Supreme Court recently overturned Chevron finally after not applying it for a long time, but it had still been applied at the lower court level. Lemon was the same way. At the district court level, attorneys advising their clients, Lemon still had a lot of teeth, but when you would get to the Supreme Court, it was always unclear how it would shake out. And that's not really how law should function. You shouldn't have to guess at whether something is legal or not whenever you're doing it.
Which plays interestingly into the discussion that we just had about whether or not the Fifth Circuit is acting within the strictures of its authority by saying Stone is gone, because we're operating in this kind of zombie wasteland, right? And it helps attorneys and district judges in the Fifth Circuit to know, okay, yes, we're just going to ignore Stone. Stone is gone. But at the same time, it's not really clear whether or not that's within the authority of the Fifth Circuit to do. So there's no real boundaries, I guess, on the authority that they exercise there.
Well, I mean, I guess we're about to find out.
Yeah,
because there's almost no way that the Supreme Court doesn't take this case.
I want to walk down that road so bad, but I know that if we do, we won't have time to get through to the rest of this. So Lemon is dead. The zombie has finally been double tapped. He's in the ground. Okay, so what does the court end up doing? What test do we put in place instead? If you guys don't have it written down, I do, because it's a little bit of a list.
Well, I have the hallmarks, if you want to get into that.
Can we just, before we get to the hallmarks, what the court does as sort of a step one, is says we should be going back to the text of the Establishment Clause. And what's prohibited is the establishment of religion. And it says, okay, we have to understand what an established church would have been at the time of ratification, whether that be ratification of the First Amendment originally or ratification at the time of incorporation in 1868. And it says it looks at what established churches were, because states at the time did have established churches. There was a long history of established religions in other countries like England. And it says, what are the, as you can go out, lay out, the hallmarks of an established church? And that becomes the test.
Yeah.
Right.
And like if we look at Walls v. Tax Commission came out the year before Lemon did. Yeah. And it applied, it was looking at the First Amendment and whether a tax was allowable. And the quote from Walls, which I think is relevant because Lemon sort of changed the direction after Walls. So if Lemon's gone, then I think Walls is a pretty good place to start in terms of what precedent controls. And the quote from Walls that I thought was illuminating says the general principle deducible from the First Amendment and all that has been said by the court is this, that we will not tolerate either governmentally established religion or governmental interference with a religion. Short of those expressly prescribed governmental acts, there is room for play in the joints, productive of a benevolent neutrality which will permit religious exercise to exist without sponsorship and without interference. So that's not a test, though.
Yeah.
And so that's like a principle. How do we apply it? And Kennedy, the decision Kennedy, talked about hallmarks of an establishment of religion and what that could look like. And that's a historical approach is what's being called for. And so the Fifth Circuit adopts some of these hallmarks of religious establishment from Kennedy. And I'm just going to...
Can we backtrack a little bit about where these come from? Because they're referenced in Kennedy, but they're actually laid out in Shurtleff v. City of Boston by Justice Gorsuch in a concurrence. So these are being pulled from Supreme Court precedent, but not from binding Supreme Court precedent. This is coming from Justice Gorsuch.
That's right, because while Kennedy mentions these hallmarks and that there should be some, that's not really part of the holding, and it's more of a nod to what the hallmarks might be more than it is binding precedent. That's right.
Right. Kennedy is not saying, here's the test, guys. But importantly, that's exactly what this opinion, what Nathan is doing, is saying, here's the test. Fifth Circuit attorneys, Fifth Circuit district judges, here is your test. And it's these 6 elements, I don't even think they're couched as factors, from Justice Gorsuch in Shurtleff.
And
Hallmarks.
Hallmarks, I'm sorry. They're, what's the difference? Chance, can you articulate that for me?
Well, hallmark is a factor, but a factor is not necessarily a hallmark.
I think Hallmark is the source of our greatest Christmas movies. So.
Yikes. That's a hot take.
There are things that you can look at, right? Like it's sort of like when you're doing the Commerce Clause cases, and when you talk about the Lopez Morrison considerations.
Oh my gosh.
They're not factors. They're.
Someday we'll talk in great detail about the Lopez Morrison considerations. Today is not that day. Nathan, let's talk about the hallmarks. What are they?
Just to disambiguate, the case is Nathan, but I am not representative. I'm not the plaintiff, Rabbi Nathan, from that case.
Yeah.
So the hallmarks of the case are going to be governmental control over religious doctrine, governance, and church personnel. That's number one. 2, compulsory church attendance. And this will be tested later. 3, compelled financial support, especially in the form of land grants and religious taxes. 4, prohibitions on worship in dissenting churches. 5, use of church institutions for civil functions. And 6, restriction of political participation to members of the established church.
Okay, so I'm sure we all want to talk about how we would apply these factors. But let's start on the front end by talking about how the majority actually does apply these factors. What does the majority do to get us to the gold thumbs up, yes, state of Texas, you can require this of your schools?
Well, I think maybe first, not to derail the outline, but I think maybe first it's important to say like why they thought it's appropriate to look at these factors.
Yeah.
Because what they're trying to figure out is what are the things that someone at the time of ratification would have recognized as an established church. And they're saying, like, if you look at the body of established churches, they all had these sort of, or mostly had these 6 things.
When we say established, some of the states at the time of ratification of the Constitution, some states actually had an established religion of the state. And
Because
that
the First Amendment did not apply to the states at the time.
Right.
Yeah.
And so it wasn't like the First Amendment changed that. So even going forward for a number of years, up till 1833, I think the last establishment was repealed, different states established different religious institutions of the state. And that's the thing that was prescribed. The federal government could not do that. That's what the First Amendment prohibited.
So really what the majority is trying to do here is to make the word establishment carry some water, to make the word establishment mean what it meant at the time of the founding, which it is so easy for us to superimpose our preconceptions about what it means to establish something. But that's why we're looking at these hallmarks, is to say, what does it mean to establish something? And they looked at those establishment clauses from the state and then also at the disestablishment of those same churches to determine what establishment actually is.
Yeah, and for like former philosophy majors like myself, we're all familiar with this exercise when you say, like, what is a chair? And you would say, like, well, it's a thing for sitting, and it has these hallmarks of what make it a chair. Like, there are all sorts of things in the family of chair, but they have certain things in common, and that's the exercise that they're doing there.
Might you call them factors for consideration of what makes something a chair?
Hallmark factors.
The hallmark factors. Okay, so as the majority is looking at these hallmarks, they don't do a whole lot of like deep dives into any one particular hallmark. They spend a lot of time talking about this concept of coercion, which is ironic because we kind of moved away from that in Lemon, but they don't like hunker down and say, okay, this is not government control over religious doctrine. This is not compulsory church attendance. This is not compelled. They don't do that.
Yeah, which is interesting.
Yeah, instead they kind of land, I think the real pivot point of the opinion where the majority lands is that there's no real analog that a simple passive display of a Ten Commandments decoration, like the Ten Commandments itself being on the wall, would have been considered by people at the time of ratification to be an established church. Like that's kind of where it all shakes out, because they're not, the majority opinion says they're not requiring particular instruction. The law doesn't require particular worship practices or that students do anything with the Ten Commandments. They treat the test to be applying these hallmarks to the existence of a Ten Commandments picture on the wall.
And I think that the court sort of wraps itself in the Kennedy decision a little bit. And because when Coach Kennedy goes out into the middle of the football field and prays, that itself was sort of a passive display of religion. that no one was compelled to go out there and listen to his prayer or pray with him or anything like that. And so I think that's why the court is very interested in attaching itself to Kennedy with this opinion. But there's some things that are really different about this opinion versus Kennedy. And I think the biggest one is that there was no law that said Coach Kennedy needs to go out to the middle of the field and pray.
Yeah. And I don't know if we're skipping over if anyone has anything else to say about the majority. But I think that that's one of the things that if you were going to critique this without, you could agree, for example, with the 6 hallmarks.
Yeah.
But the application sometimes is, people may disagree about the application. And one of the critiques that probably stands out just right off the bat is there potentially, one could argue, saying, is a passive display an establishment? But the question before the court is not really, are the 10 Commandments anywhere in a classroom necessarily an establishment of religion?
Right,
the thing before
we're not talking about a teacher who hangs the 10 Commandments because she wants her students to learn the 10 Commandments. We're talking about something fundamentally different.
You're talking about a state statute that declares that every classroom has to have this particular document in this particular way displayed in this particular place.
Using these exact words.
Right, and that may be a different question. And it's going to be interesting to see how that shakes out when it goes up on the court, to the Supreme Court.
And I think, too, there's just to my eye, when I read this at a glance, the one that stands out to me is compelled financial support. Because so if you look back at Stone, this is one of the distinctions between this case and Stone. In Stone, all of the 10 Commandments that were required to be put on the walls were provided by private donation. And that private donation meant that there wasn't actually any state funds going to this particular project. It was just a requirement, hey, you're going to receive this. We've got promises for all of these 10 Commandments. And once you have it, you must hang it on the wall. Here, you can't. Some of them are donated, yes. But if they're not donated to you, the state must use its own funds to purchase them and give them to you. Which, to me, even just that basic language of compelled financial support, it sends up a red flag in my mind that this is compelled financial support, that the state dollars are going to go towards these 10 Commandment displays that are then going to be put on the wall. But that's actually completely ignored in this case because the plaintiffs didn't raise it. So we have a party presentation rule on that particular front. They didn't bring it up. The court doesn't really talk about it except to say that we don't think it is, but even if we did, the plaintiffs didn't raise it, so we can't do anything with it.
I agree with you on the compelled financial support. And also, if we look at compulsory church attendance as one of the other hallmarks the court mentions, it doesn't analyze that one a lot because it doesn't say you have to go to church, right? But public schools have compulsory attendance. And so does having religious statements in the public school convert them into some way into church? Church isn't really defined, and we don't really dig into that factor to say, well, what does it mean for compulsory church attendance? At the founding, there were no public schools. And so the idea of compulsory school attendance as an analog to compulsory church attendance doesn't really exist, right?
Yeah, I think that's true. I think really that's what, it comes back to the bigger point is you can agree with the 6 hallmarks.
Yeah.
And then the application, it would have been interesting to see them walk through the 6 hallmarks a little more carefully.
They don't lay it out step by step.
Because for example, just the fact that the state spends money on something doesn't create an establishment clause problem, right? Because we know from Trinity Lutheran and some of the other cases that have recently come down that the state spending money's fungible, of course, and just because a religious institution gets money, that doesn't create an establishment clause problem. It would have been nice for the court to walk through the application here.
Particularly because we're not just talking about resurfacing a playground. We're talking about literally purchasing a religious text and then forcing it to be displayed in a classroom. There's in my mind, there's a difference there, and I would have liked to see the court struggle with that a little bit.
I mean, it would have been nice for them to walk through it. I mean, of course, there are Bibles in school libraries that were, of course, purchased and things like that. But I would push back that any time that the government spends money, that creates an establishment clause violation. But it would have been nice for the court to walk through it. But to Nathan's point, I think it's interesting that they didn't really grapple with the fact that compulsory public education was not a thing at the founding. And so you have to draw that analogy. Does compulsory public education as it exists today change the analysis here? And you don't really see that grappled with in the opinion. I think that would have been nice to walk through as well. Not taking a position on how it would have shook out, but I think if we're going to apply this hallmark test, when you have a state monopoly on education, when you have mandatory attendance, when you have something that's creating state orthodoxy, how does that apply in the public school context?
What do you mean by creating state orthodoxy?
So here you have, for example, the state that's said not only the Ten Commandments, but only this version of the Ten Commandments shall be posted. But even at like a deeper level, and I think this is something that the court should have grappled with and given some guidance on, if you apply the test the way they applied it, not the 6 hallmarks standing by themselves, which I think are fine, but if you apply it this way, under their opinion, the state of Michigan, for example, could adopt a statute that says each public school shall, above the entryway to each classroom, have this exact quote: "There is one God and Muhammad is his prophet." And that would not trigger Establishment Clause scrutiny under this opinion. And I think the court needs to explain why that's not the case, or if it is the case, maybe they're okay with that. But we don't get that from this opinion. I think we get what is a thoughtful originalist test. I think they're looking in the right area. But the actual analysis of it, I think, can break down. Like it's going to be interesting to see once it's fully briefed up at the Supreme Court and all of the various advocacy groups have an opportunity to opine how that shakes out. Again, not taking any position on how it will, but just saying how you apply it is the devil's going to be in the details.
Yeah. I think the Louisiana law is a good comparison. Yeah. Because I think the Louisiana law is an easier pass.
What Louisiana law are you talking about?
So the Fifth Circuit recently declined to decide the merits of a case related to a law that a Ten Commandments
the one
law.
that I was talking about earlier with respect to ripeness. Yeah. Okay, so the Louisiana law is a better case for the government.
I think so, because whereas in Texas, as you mentioned, the state controls the like what exactly the precise text, like you shall have this text. Yeah. Whereas Louisiana says there's some state guidelines, but local control over like what version and things like that. The Texas law says you can only have the Ten Commandments on this display. Louisiana law allows for things like the Mayflower Compact, the Declaration of Independence, the Northwest Ordinance. And so when you're looking at Louisiana law, also the Texas law, like it has to be in a conspicuous location in the classroom in Louisiana. It doesn't have any guidance on that. But I think specifically when you're looking at things like the Mayflower Compact, the Declaration of Independence, these things are referencing natural law, the Northwest Ordinance. These things are referencing natural law and sort of the origins of Western law. Whereas if it's just the Ten Commandments, it's not. We don't have that context of like this is like the foundation of our law, and so it just looks like more of an establishment of religion versus this is how we got where we are today, which is more of a historical look.
Which I think brings us down to something that if the Supreme Court were to adopt these 6 hallmarks, we might need some factors for the question of what makes something, especially a public school. I don't even think there's an analog. So what makes a public school look too much like a church? At what point do we cross that line? And like Nathan just said, where you're talking about the Ten Commandments sitting in their place among our civics, right? This is part of American history. Mm-hmm. This is part of world history to a certain extent. Mm-hmm. It is part of our civics curriculum. Or are we saying this is a theology that you should read and should apply to your life? And how do we know when we have crossed from that, this is part of our civics education, into our now you are looking too much like a church? And I kind of tend to think, I could be wrong on this, that simply requiring the posting of the Ten Commandments doesn't make us look too much like a church, but I could be persuaded either way on that.
I mean, I think the what is, I mean, the how is just as important as the what. So, for example, the University of Texas, where I went for undergrad, and where I teach now.
I like that that's the afterthought.
Yeah. As everyone loves their undergraduate institution. And so the tower there at the six pack has a Bible verse on it. You shall know the truth and the truth shall make you free. That's a passive display of scripture at a publicly funded university. No one thinks, at the time of ratification that would have been considered an establishment of religion. That's a decoration that's put on a building. That's the what. But the how matters as well. Like, do you have, for example, the state saying this is the text that we're going to have and teach everyone, and this is going to be posted everywhere, and it's going to be this particular version of the text? At some point, when you're talking about instruction and religious doctrine, that starts to look more like creating a state orthodoxy on a particular matter of religion. So, for example, if you had a Massachusetts law that said in every classroom, there would be a statement that says there's no salvation outside the Catholic Church, right?
Ooh.
Is that statement in every single classroom taking a side, for example, in a religious disagreement where it's now creating an orthodoxy for the state? And I think these are tough questions. I think the Fifth Circuit's doing it right, trying to understand how this would have been viewed at the time of ratification. Would this be an establishment? But they are, in fact, tough questions at the margins, and I'd like to see the courts wrestle with it a little bit.
And part of this is like an outflow from cases like Trinity Lutheran. The reason that Trinity Lutheran Church in that case was not given funds, there were publicly available funds for playground resurfacing. That doesn't sound religious at all, and it's not. But the state said, we're not going to give you those funds because if we did, that would be an establishment of religion.
Yeah.
And so they basically precluded Trinity Lutheran from doing that. And Trinity Lutheran's argument was, well, that's a violative of our free exercise of religion.
Yeah.
You're saying I can't get money that everyone else can get because of my religion. That's a problem. But what it does is it puts the free exercise clause directly up against the establishment clause, where there's it's either going to violate one of those things or the other unless you follow this very narrow pathway of government. And what the Walsh v. Tax Commission says, and what I think is still good law, is that there's supposed to be some play in the joints. There's supposed to be an area between the establishment clause and the free exercise clause where the state can do something.
Yeah.
And we just don't know exactly what that is.
And I think it bears mentioning, too, that in this case as well, we haven't talked about it at all, but in Nathan v. Alamo Heights, there is a claim of free exercise. The parents came and claimed that this was interfering with our ability to educate our children according to our own religions. Mm-hmm. And that is a fair criticism. And I wish that we had a little bit more time to get into this, but we're already bumping up against time a tiny bit. So I'm going to push you guys to the last issue that I thought was interesting here. And, well, there's a lot. There's so much in this.
Can I make one very quick comment about to Nathan's point? It'll be quick. I'll try. Lawyers are not always quick. But it is important to remember that how far the pendulum had swung the other way under Lemon. That basically it was mandating a type of anti-religion and mandating a type of hyper, I guess, anti-religion, maybe not all, but at least secularization,
right,
that maybe the establishment clause did not require.
Yeah.
And so it's going to be interesting to see, now that that's swept away, how do we get to something that looks like more of an original understanding of the First Amendment? But
without swinging too far into the issue of established state religions at the time of ratification, because we're not there. We are at 14th Amendment and not at First Amendment.
Right.
As far as time frame goes. Okay, so last issue to discuss today, standing.
Yep.
So the court, in the majority, very quickly kind of brushes past standing and says, yes, the plaintiffs have standing in this case, but as Chance is fond of saying, we went into this to help people and we spend most of our time litigating standing. Yep. So the court says, yes, absolutely, the plaintiffs have standing. A couple of the concurrences, Andrew Oldham, I think, Judge Oldham, writes a concurrence just very skeptical of this concept of offended observer standing. Chance, what is he saying, and do we tend to agree with him or not?
Okay, so I'll be law professor Chance for just a moment.
Be law professor Chance.
So to get into court, courts to have jurisdiction and everything, it's granted by Article 3 of the Constitution, which says that courts have jurisdiction over cases and controversies. In other words, you can't just come to court because you don't like a law. You have to have something that would be considered a case or controversy at the time of ratification in order to get into court. And what that ordinarily means is you have to show that you're injured in fact by the thing that you're challenging, that in a way that's different than the general public at large. You have some sort of specific injury. Now, the traditional way that we usually litigate is you're a regulated party. Like the statute or regulation that you're challenging makes you change your behavior in some way, or you'll face penalties. And that's the easiest way to have standing. But in the Establishment Clause context, for years, there's been this idea that just looking at a passive, religious display in some way offends your religious sensibilities, and that is an injury for standing purposes. The fact that I don't like it, it's contrary to my values, and therefore that's an injury if I have to just be in the presence of this religious object, and therefore I have standing to challenge it under the Establishment Clause. Judge Oldham, and I believe Judge Willett and Judge Ho joined this separate concurrence, argue that they're not sure that that's standing. That's not an injury in fact at the time of ratification, because there's no analog in the 1780s for offended observer standing. that would be sufficient to be an injury to create a case or controversy under Article 3.
And the problem with if you have offended observer standing is it looks a lot like just a person that has no stake, no interest at all in the outcome of the case, just challenging laws willy-nilly.
Right.
And then there's tons of federal cases and the courts can't deal with all of them. And they don't really, it doesn't matter to them if they win or lose, ultimately.
Yeah.
So we are plaintiffs' attorneys. Why would we have a problem with this? We're always trying to get in the door. Wouldn't it be nice to just have another arrow in our quiver to say, yeah, we have standing, we're offended by this.
Well,
Let's go.
I mean, if your originalism always benefits you, then you're not really an originalist, right? It's like, Justice Scalia used to say, if a judge always likes his opinions, then he's not being faithful to the text, right?
Mm-hmm.
That sometimes your outcome should be separate from what would benefit you. And I think, from our perspective, we are originalist first, and we care about what Article 3 actually says on one level. And so we want to make sure that we're being faithful to whether this is a case or controversy at the common law at the time that the Constitution was ratified. But I think more importantly from our perspective is because there's these weird doctrines of standing that are sort of made up, whether it be offended observer standing or some of the third-party standing doctrines, courts,
or I wanted to see the birds and now I can't see the birds.
Now I can't see the birds.
Yeah.
You create these weird standing doctrines and then they leach into what should be straightforward regulated party standing. Like a lot of these doctrines, a lot of this language, then the government will use it against you in cases where it really shouldn't apply at all. So, for example, in our cases where someone is directly regulated by a statute that on its face says you can't do X or there will be penalties, and then we're having to deal with a bunch of doctrines that are developed in other cases, which in what really should be a straightforward standing case.
So it ends up actually, at the end of the day, creating more hurdles for people
Yeah.
who are actually injured
Yes.
because we've allowed exceptions, and then there's exceptions to the exceptions, and basically we've just created a cloud of muddy case law around standing, and that's where we live. We swim in the cloud of muddy
Because
case law.
in every case, the government's going to argue that you don't have standing, that your case isn't ripe. We actually, in one of our cases, the federal government had hammered stakes into the ground on our client's property, and the stakes claimed it as federal property, and we still got a motion to dismiss claiming that it was not ripe and our clients had not been injured. And it's like, you literally claimed their property and hammered stakes in the ground.
You came and you took it. How are we supposed to say that you don't have standing? So we're running very short on time, but before I wrap us up, any other thoughts on this case that the world just absolutely needs to know?
Well, if you're keeping score at home, the Fifth Circuit upheld the Ten Commandments law from Texas 9-8 by one justice majority, saying that under these 6 hallmarks, which we've been talking about, that this does not run afoul of the Establishment Clause of the Constitution, the First Amendment of the Constitution. And we're almost for sure going to see an appeal to the Supreme Court. And so we might be talking about this law and this opinion even down the road in just a little while.
Yeah, and then at that point, I can say again, at the beginning of the podcast, we're bringing you Supreme Court cases as they drop this session, and I won't be lying.
Even before they drop.
Even before they drop. Yeah. All right, well, I think that brings us to the end of today's docket. Thank you so much for joining us, and if you've enjoyed our conversation today, please leave us a review, and join us next time for more Rightly Decided.